Hi, I'm Greg Dell here with Cesar Gavidia. And Cesar, we've handled thousands of claims against the Cigna insurance company, also known as Life Insurance Company of North America.
Right.
And in this particular video, I want to focus more on the aspect of after you've exhausted administrative remedies and filed an appeal, the only thing left to do is file a lawsuit.
Yeah.
And as you know, we file those lawsuits all over the country. We've helped people in just about every single state, and we can file those lawsuits in just about any federal court across the country. But let's talk about what a claimant should expect once the appeal's been done and their only remedy is to file a lawsuit.
Okay. So, Cigna is a little unique, and every disability insurance company is different. But right before we get into the issue of the lawsuit, generally Cigna allows you two administrative appeals, which the first one's mandatory, and the second one is typically a voluntary one. And that, I get a lot of questions as well. Now that my first mandatory appeal has been exhausted and we weren't successful, what do we do now? We have a second appeal, or do we file a lawsuit? And I think that sometimes just comes down to a question of, well, is there additional evidence that you need to supplement the administrative record with that you couldn't get into that first appeal? Or is there some additional piece of evidence or some issue that you need to take an opportunity to confront and address now that you're not going to be able to do later if you file the lawsuit? So that's kind of a strategic decision you need to decide with your attorney, or if you don't have an attorney, on your own.
Right.
But hopefully you have an attorney to deal with this type of thing and kind of walk you through it. The next step would be, assuming that you've exhausted all those appeals, is to file your federal lawsuit. And that what would happen in that case is the lawyer would draft the complaint alleging that Cigna, or LINA is actually who you're suing, Life Insurance Company of North America, it has violated ERISA by arbitrarily and capriciously refusing to pay your disability insurance benefits.
Okay. And let's break it down even more simple. What's the reasonable time frame that a claimant should expect for the whole process to take place?
They generally have about 90 days, 45 days, then they can seek extensions up to an additional 45 days to decide your appeal. So once that's been done and you filed your lawsuit, they usually have between 20 days and 30 days to respond to that lawsuit. I mean, the rules say it's generally 20, but by the time their lawyers get involved, they need to seek an extension, and the courts almost always grant those. So you're looking at 30 to 40 days before they actually respond to the allegations in your complaint. And most of the time, I'd say 99% of the time, LINA's denied those allegations. They say we reviewed the claim, reasonably. We didn't do anything wrong. You're not entitled to disability insurance benefits. And after that's been done, then you're generally in the normal course of litigation.
And how long from filing of a lawsuit until completion is the average time that it's going to take for a lawsuit against Cigna?
Well, it all depends because some judges will set a 6-month trial docket. I mean, it's very rare, but some judges will say, all right, from the time you filed your lawsuit, you have 6 months to either resolve this case or we'll see you in trial in 6 months. Some judges their calendars and their dockets are so backloaded that you may not be seeing a trial in your ERISA case for anywhere from a year to 2 years, depending. And if depending on what happens through the course of that trial, you may be looking at appeals beyond that to higher level appellate court. But in most cases, we engage in what's called mediation, where it's a form of alternative dispute resolution, where we meet with the disability insurance carrier and their lawyers to try to resolve the case. And usually you can expect to be engaged in that within 3 to 6 months from the time your lawsuit's filed.
And the mediation's required by the court?
In most cases they're required, yeah.
Now, in terms of what's the biggest challenge in whether it's Cigna, which is who we're focusing on now, and it's a ERISA case and there's discretionary review, is there going to be a jury trial for the claimant?
There's not going to be a jury trial in an ERISA case. ERISA provides just for what are called bench trials, or a trial before the federal judge. And what that federal judge is doing is reviewing the administrative record. And that's why those appeals that we discussed initially are so important, because that's effectively all the judge is looking at to determine whether Cigna or LINA acted arbitrary and capriciously or unreasonably if there's discretion in that case. So there's no jury trial. You don't get what you see in Law and Order, where the lawyers are arguing before a panel of jurors, and then they go and deliberate and decide whether you're disabled. This is left up to one federal judge to decide whether you're disabled or not.
And then when we were talking about timing a minute ago, what I find is the judge will usually give you 6 months to a year till you finally get your bench trial. And then you submit a bunch of papers, whether it's a summary judgment or a motion for final judgment. And then the judges usually take anywhere from 3 months to 9 months to issue a decision. And there's nothing that we could do, although the rules say that basically if they don't make a decision, I think within 6 months, then you file a notice of no decision and you can push the judge to do it. But basically you're kind of sitting around waiting for 6 months for the judge to issue that decision.
Yeah.
And there's not much. And then when a decision comes, of course, there is an option for either the plaintiff or the defendant to file an appeal. And the appeal process is usually 12 months to 18 months.
And that's a totally different animal. I mean, there you're basically looking at it could be before a tribunal of appellate judges deciding very legal and technical issues concerning that disability claim, and not necessarily whether you're disabled or not.
And let's just touch on a little bit who has the upper hand if there's a discretionary clause in the Cigna disability policy? Is it the claimant or is the insurance company when you actually are in litigation?
Yeah, so in these Cigna cases, they often argue that they're afforded discretion through these discretionary clauses which appear in their disability insurance policies. And what a discretionary clause is effectively language which states that Cigna or the disability insurer can determine the terms and conditions and interpret the terms and conditions of the plan and decide your disability claim in effectively any way they see fit. And of course they say they're going to do a reasonable job at that, but and as you know, and that's not true in all cases, and in every case. So what happens is, and how I explain it usually to my clients, is that it's almost as if assuming they deny your claim, and you have to go to court, the judge, based on that discretionary clause in that policy, effectively has to give the disability insurer almost like the benefit of the doubt that their decision was correct. Okay, so what that means is that the judge could determine by looking at the facts and the case that indeed you are disabled, that all the facts and all the medical evidence and all of your medical records and all of the proof establishes that you're disabled. However, Cigna or the disability insurer arrived at that decision reasonably, that you're not disabled because they consulted a physician, or because that they sent you to an independent medical exam, or because they considered all of the information that you presented before them and they had some in-house physician consultant decide that, based on what we looked at here, you're not disabled. The judge could still determine that Cigna was correct and that you are not entitled to your disability benefits because the decision based on that discretionary clause in that policy was not arbitrary and capricious.
So in that case, it would be like the process was followed appropriately, but the substance of the claim, the judge thinking the claim is disabled, doesn't matter because the insurance company, Cigna in this case, acted reasonably. And that's the point that we argue and we've lobbied Congress for and continue to do on a daily basis, saying how unfair ERISA is. And there's about 15 states or so where they've made these discretionary clauses. They've banned them and said you can no longer issue disability policies that contain these discretionary policies for all of the reasons that you just addressed.
Right, and unsurprisingly, the disability insurers fight all of that legislation. Mm-hmm. They try to argue, well, ERISA preempts it, or it, our policies were effective prior to the date of the issuance of that legislation. So these discretionary clauses are critical to these disability insurance companies making these decisions, and any legislation like that, they're going to try to fight tooth and nail.
Right, and I don't want someone watching this video to think, wow, it sounds like it's impossible to win a ERISA disability lawsuit, because it's not, and there's victories every week that come out in favor of plaintiffs, but every case is super fact specific. It really depends on all the nuances of how the disability insurance company reviewed the claim. And same time, like if someone calls us and we haven't even done the appeal yet, even though we submit what we think is a great appeal, we don't know how strong the lawsuit's going to be until we get back the decision from the insurance company in which, if they were to deny the claim, and review what kind of analysis did they do on the file. Because if they ended up doing an unreasonable analysis, then we think we have a very good lawsuit. But if while we usually disagree with their decision, if they did a fair or reasonable review in accordance with the law, then it makes that lawsuit very hard to win. Now,
Yeah.
regardless of the fact that we may think, look, the insurance company has a 70% chance of winning and you have a 30% chance of winning, very often we're still able to reach some kind of settlement with the insurance company, which eliminates the risk of a claimant having to have an all or nothing mentality, and then they can at least recover some kind of money on the claim as opposed to getting nothing.
Right.
And what saddens me that you and I often see is that there's many people who just say, you know what, they denied me and I'm going to go back to work in some kind of capacity, you know, very challenged, probably unable to do the job, but they got to survive and they don't bother with the lawsuit. And that's disturbing when the people don't go forward with that. So if you have a Cigna disability claim and you're either considering an appeal, you've exhausted your appeals, you have to file a lawsuit, no matter what stage you're at with your Cigna claim, any of our disability lawyers can help you with your claim. We can help you anywhere in the country. We always offer a free consultation, and we look forward to the opportunity to speak with you.